Hello, everyone in YouTube land. This is an introduction into equal employment opportunity complaints in the private and the federal sector. So, for this session, we're going to just go over how to file an EEO complaint in both the federal and the private sector. It's a lot more complicated in the federal sector if you are a federal employee. Private sector, it tends to be a lot simpler, but your avenues of recourse are not as extensive as the federal sector. So it's simpler, but there's just a lot less that you can do to file a complaint and get that complaint redressed when you're in the private sector. So let's jump into it. Federal workers. So let's talk about the federal workers that want to file a complaint of discrimination. The rights of federal employees asserting discrimination claims are governed exclusively by Title VII of the Civil Rights Act, and that act prohibits discrimination in the workplace on the basis of race, color, gender, religion, and national origin. Unlike private sector employees, federal workers asserting claims for discrimination in the workplace have a different procedural framework that they must adhere to. So it's a little more complicated. The first step in the process for federal employees is filing an informal complaint with their agency's EEO counselor within 45 days of the discriminatory act. And those timelines are very strict. You don't have a lot of time. You feel like you're being discriminated against. Someone does something to discriminate against you. You have 45 days to file that complaint. Only 45 days. It's very strict. And you have to get in touch with an EEO counselor. Okay, now we're going to go back and forth between the federal and the private. So I'm going to talk about the rights that private employees have. The most prominent situation in which employee rights are basically equal will be when it comes to the protections against discrimination. So there are a number of federal laws that bar public and private employees from discriminating against employees for a variety of reasons, such as what I just mentioned: race, color, religion, national origin, sex, sexual orientation, and gender identity, according to Title VII of the Civil Rights Act of 1964. You have age that bars discrimination. That is the Age Discrimination Employment Act of 1967. Pregnancy, that is the Pregnancy Discrimination Act of 1978. You have disability, which for federal employees, that's the Rehabilitation Act of 1973. For private employees, you have the American Disabilities Act of 1990. Pay discrepancies based on sex, you have the Equal Pay Act of 1963. Genetic information, you have the Genetic Information Non-Discrimination Act of 2008. Whistleblowing, you have the Sarbanes-Oxley Act of 2002 and the Whistleblower Protection Act of 1989, just to name a few. But there are instances in which federal employees will enjoy greater discrimination protections than private employees. So let's get into it. How are the federal employees' rights enhanced? Federal employees enjoy enhanced rights that are similar to those in the private sector, but with slightly greater protections. As an example of enhanced rights, almost any federal employee that suffers from employment discrimination will be able to rely on federal law to seek a legal remedy for the discrimination they face. In contrast, many private employees do not have this ability because the federal anti-discrimination laws do not apply to all employers. For example, Title VII of the Civil Rights Act of 1964 doesn't apply to employers with fewer than 15 employees. So, if you work for a business with only 14 employees, your boss could fire you because of your race, and there's nothing that you could do about it under Title VII. Some states have their own anti-discrimination laws to address these situations. For example, Virginia's Human Rights Act prohibits discrimination for employees with more than 5 but less than 15 employees. And Maryland's anti-discrimination employment law applies to employers with 15 or more employees. But when you work in the federal government, you really have to worry about the size of your employer being a limitation on your legal rights, as most federal agencies have more than 15 employees. So let's talk about the Equal Employment Opportunity Commission. The Equal Opportunity Commission, also known as the EOC, is a federal agency that is vested with responsibility for enforcing this country's anti-discrimination laws. And the EOC enforces rules set up by Title VII of the Civil Rights Act of 1964 that prohibits discrimination on the basis of race, religion, national origin, sex, and color. The EOC also enforces the rules established by the Americans with Disabilities Act and the Age Discrimination in Employment Act, which prevent employees from discriminating on the basis of disability status or an individual being 40 years of age or older, respectively. The EOC is vested with a lot of responsibility for preventing unlawful discrimination in the workplace. The EOC enforces rules and regulations within the scope of its authority, and it can provide guidance on how federal anti-discrimination laws are to be applied to protect workers' rights. Companies and employees should make an effort to understand the EOC rules because the regulations advocated by the Commission should greatly impact how employees interact with workers when it comes to civil rights issues. But please be mindful that they usually don't. And what I mean by that is that most companies have no idea what the EOC has advocated, and most employees don't either. So if you want to know about these rules, you can just check out the EOC's website to understand what the rules are, what your protections are as a worker. The EOC is a vast federal agency. It's far more involved with complaints it receives from the federal employment sector as opposed to the private employer sector. And even in the federal employment sector, the EOC is not nearly as effective as it could be due to many layers of pointless bureaucracy, which we will explore in my next video on the formal complaint process. The EOC can conduct an investigation if a worker makes a complaint against an employer who is covered by the EOC's laws. Well, the laws that the EOC enforces, they're federal laws. Most private employers are covered by these laws if they have at least 15 employees. Please note that the EOC can conduct investigations, but for them to actually do it is quite rare. They don't often do it. The EOC receives far too many complaints of employment discrimination to conduct an investigation for every complaint that it receives. It also depends on what the jurisdiction is. A lot of the EOCs in the southern jurisdictions don't do much of anything at all. I'm just going to be honest. The EOC is supposed to evaluate the claims made against employers and make a finding of discrimination or not. But mostly the EOC pushes these private employer complaints through its system without examining them at all. Again, I'm just being honest. If, in the rare case, the EOC determines that the employer engaged in unlawful discriminatory behavior, the Commission will try to settle the case. And if no settlement is reached, the EOC can file a lawsuit and litigate the case on behalf of the complainant. However, again, this is rare. I would guesstimate that less than 1% of all cases filed does the EOC file a lawsuit on behalf of the complainant, even when the discrimination is blatant. And a lot of this has to do with chances for success. Most of the blatant unlawful discriminators, as well as all kinds of other legal violations, come from big corporate employers who have deep, deep pockets, and they can fight off any kind of lawsuit that will be filed against them. So bringing a discrimination complaint is often a David versus Goliath endeavor. While discrimination victims may be required to make their complaint with the EOC first for certain kinds of discrimination claims arising under federal law before filing a lawsuit in civil court, some discrimination victims do go on to sue their employers. Be forewarned, though, that taking a discrimination complaint into federal court is quite the costly endeavor. The EOC, upon closing its investigation, or if victims wish to pursue private legal action, can provide victims affected by unlawful discriminatory behavior with a notice of right to sue. While it's not required in all cases, for example, it's not necessary for lawsuits brought under the Equal Pay Act, getting this notice of right to sue from the EOC often is a precursor to pursuing a damage claim in civil court. So that's all for the laws. I'll come back. I'll do another video on the informal process within the federal sector so that you can understand, if you are a federal employee, how the process begins. And the informal process is a pretty simple process, and I would recommend taking advantage of that process, but you need to understand that process before you do. But I would recommend using that process to try and work out the discrimination complaint, and I will explain why in the next video.